So then, welcome, welcome you to this class. This is Legal Writing and Drafting, March 2023. We are going to tackle today question 1, 2, and 3, Legal Writing and Drafting. Yeah, so the other videos are on the website. In the website, I've researched year 2008 to 2019 question and answers, which goes for 500. Then June 2021, 100. Then there are videos. I usually do part 1 and part 2, question 1, 2, and 3 in each and every paper. So November 2021, part 1 and 2. November 2021, part 1 and 2. April 2022, part 1 and 2. October 2022, part 1 and 2. Now we are at March 2023, part 1, where we are going to do question 1, 2, and 3. This is 24th February 2025. We are doing this ahead of April 2025 exams because legal writing and drafting has been one of the most second field subjects in the last 2 years, 2024 and 2023. And I realized there was not a lot of content on the website. So legal writing and drafting is divided into 3 parts. There's legal writing, legal drafting. Legal writing, you can be asked the other questions. What is a paragraph? What is a sentence? Legal or drafting question, where you told to draft a paragraph, sentences. What is wrong in sentences? Wrong, plain English. Legal drafting, you can be told to draft any legal drafting document. Yeah, so it's good to even a commercial agreement you can be told to draft under here. So it's good to acquaint with any kind of legal drafting, case briefs, legal opinions, letters, arbitration agreement, anything. You can be asked to draft any kind of legal document. It is there. Also, you can be also, of course, be asked the other questions on here, like what is a demand letter, what are the content of a legal opinion, what is a deed poll, yeah, what are content of a deed poll, and such kind of things. So we are going to tackle each and every document, legal drafting documents, which have been tested in the past from 2008. So when we finish to November 2024, any legal drafting document which has not you not have looked, you are going to go back to the part B of year 2008 to 2019 and draft some documents. Yeah. So even mock drafting. So the other third part of legal writing and drafting is legislative drafting. Here you can be told, ask about the other questions, like what is a bill, what is a policy, what is a cabinet memorandum, how the processes of a bill in parliament, how that county assembly make laws, all these kinds of questions. And of course, there is drafting questions. Most of the time they ask drafting questions, not theory. Amending a registration, drafting regulations, drafting bills, cabinet memo, policy, memorandum of and objects. And yeah, we are going to deal with every kind of drafting document that have been tested under legislative drafting. So keep on looking to the videos. Yeah. So we enter to the business of the day. We are now going to look at question 1 of March 2023, which is on your screen. Can you see it, Nicole?
Yes, I can.
Yeah, so I'm going to read It had part A and B. So question 1A, you are people in a busy law firm known for your pro bono lawyering with a bias towards child maintenance cases. You secured the pupillage position because you were able to convince the firm that you are the best student in ATP 103, legal writing and legislative drafting. One of the firm's clients, Mjeuri Sana, has been served with a demand letter below from a lawyer acting for his estranged wife, Utanijua Vizuri. The letter is pasted below. Our reference, your reference, dated 24th December 2027, Mjeuri PO Box, Nairobi, dear sir. Ref, maintenance of Master Sam Mwelevu Sana. You have been promised to be paid by our client to write to you and address you as follows. You said above named child with Utanijua Vizuri. After his birth, you pretended to be broke, and since you have not been providing for the minor, to make it tragic, you blackmailed our client that unless he sends you maintenance, in quotes, you are going to expose her on social media for being a scoundrel. Your actions are so unconstitutional. Gosh, fortunately, the law has a relief towards charlatans like you. The purpose of this letter is to demand, which we hereby do, a sum of Kenya shillings 2 million as alimony towards maintenance of the child. Also, stop hovering around our client as you are witchcraft. Particulars are well within your knowledge. The legal battle that to ensure should you not respond to the letter within 90 days from the day of the letter, we make you know that the children chicken rarely urinate, if at all. We look forward to hearing from you. Yours faithfully, Wakili Mkubwa for Mawakili Hatari Sana. So the first question, 1, identify any 4 errors and omission in the demand letter. So demand letter is one of the most tested question. We dealt with it in the last papers, and it's one of the easiest to do. So if you get a demand letter, kindly look at it. So yeah, I'm projecting your Nicole answer. So I told you you do point form. You have not done that, eh? Are we together?
Mwalimu, I think I'll speak to you after the class in regards to that. I think I'm slightly confused.
Yeah. So the answer by Helen is in point form. This is what I mean, eh? But we are going to speak. It makes the marker gets your point quickly and does not lose your point. Of course, even the best and worst performing student did it, and you see his answer also. It's in point form. Of course, it's not paragraphs, but you can see how he has separated. You can see the answer.
Yeah.
Yeah. So this is a trick. This is a trick of doing these questions if you want to pass. So the drafter omitted the address of the law firm. Each formal letters need to have the address of the drafter and that of the recipient. Let's see if that is correct. So he did not put the draft omitted the address of the law firm. Each formal letter should have address of the drafter and that of the recipient. Correct? 1 point. That is 1 mark. Number 2, this should be number 1, then number 2. And the drafter make an error. made an error but not underlining the reference and also writing in small caps, the best way would be. The drafter made an error by not underlining the reference. That is not a major thing. Underlining reference is not a major. Yeah, it's not a major thing. And also writing in small caps is not also not a major thing. This is not a substantive thing. Yeah, that's not a substantive thing. So maintainers, you could have used this. Maintainers, you have given the example. So use of very long paragraph. The drafter does not focus on having a topic sentence, a paragraph, a block, and a conclusion sentence to enable the reader understand the message being passed forth. It's a point, but not not a very crucial point to give you marks. You know, this question is focusing on you on how to the main thing in a demand letter. What should a demand letter contain? The drafter does not utilize formal language. There is a lot of abusive language. For example, you are witchcraft and use of expression of feelings like gosh and threats known for your children are very rarely unionate. So that is the second point. Yeah, so here you could have gotten 2 points because, of course, the address of the recipient and the name must be there, and also you must use formal language. So what is the other thing? Looking at the question, the other thing is that the date is future date, 27 December 2027, which is not correct. You cannot put future date. Number 4, you have been promised to be paid by a client to write to you to address the issue also as follows. You don't start that way. You start by saying that we have been instructed by our client. This is not the language of the demand letter. Maybe I can let me share a demand letter. You compare and contrast. I shared the last time. So sample demand letter. This is the one I shared in last class. Yeah, so you can see it on your screen. You can see it,
Yes.
Hello?
Yes, we can see it.
Yes, we can see it.
Yeah. So, yeah, welcome, Helen. So I'm saying this is a demand letter I showed you last time. How it look like the of course the address of the recipient and the person who is sending the letter, your reference 8th June, a reference. Then we act for a client who's instructed how you should do that. We should not receive the response within the next 21 days. We are going to institute a suit. So that is a demand letter. Then you ask faithfully and in it. So when you look at the letter in the question, It does not have, we have been instructed, of course, the language here, not straight to the point that you want, legal issue, then take notice. Action are you going to take? So that is the issues with this demand letter. So Helen, answer. The advocate used abusive and unprofessional language towards the client. That is point number one. Good. The advocates are not explain or break down the reasoning behind the amount demanded. And that's not a very strong point. You don't need to explain. You can just state the amount. Then you are going on negotiation. You can break down. You usually don't break down in a demand letter. The advocate should not have mentioned that his clients promised to pay. Yeah, to tell you that. So that's another point. The time for the demand is unreasonable. So the legal battle should not make you know. So he was not given time. Was he given time?
Yes, he was given time. I was considering that 3 months is too short to come up with that sum.
So the legal battle should you not support within 90 days from the day of this letter make you? Yeah, they are even given demand letters. So he's saying the legal battle can respond and say you pay this way. It's not paying. So yeah, they are given maximum 21 days. So that also was not a point. The date is also unfavorable. It is a holiday season. The date is also unfavorable as it is a holiday season. Which date now?
Okay, I was considering the timelines within. Okay, there's a period when courts and law firms are not in operation. So I was thinking that assuming the 24th of December was within kama ingekuwa 2022. If we ignore the 2027 part and think about 24th December, there's a time when law firms and courts are not in session. Law firms are closed and courts are not in session.
Yeah.
So yes.
Helen? Helen?
Yes.
So yeah. Say what you are saying.
Oh, I was saying.
Today, I don't know. Her network is.
I was saying. Apart from the 2020, if we remove the 2027 part, which is a future date, 24th December falls within the timelines when courts are not in session mostly courts for what I've experienced, courts are not in session and most law firms are usually closed during that time. So to try and send correspondence during that time it's like sabotage. You send communication during that time when nobody's really paying attention to what is coming in terms of work. Then it will be an excuse for you to initiate legal proceedings, yet the information was not communicated within a reasonable time or during a reasonable time. Yes.
I have switched. Sorry, I've switched the internet to fiber.
Okay.
Yeah, so I know now we not. Yes.
Yeah, it's better.
Yeah, I've switched today. Don't know why Nini has problem. My phone, but now I've switched to the portable Wi-Fi, so we can continue. So what we are saying, Helen, you know all those things when you are looking at demand letter. You don't need to think about what quota are crossing or what. So in fact, what you needed to say is that just 27 December is a future date, and letter cannot be written on a future date. Unaona?
Okay.
So if you look at the answer of the best performing student, which I'm projecting, the letterhead of the firm Wakili Sana is not included. So that one Nani has already talked about it. The letter is post-dated. The letter is referred as 27 December 2027. As shared should be written with specific and current date, not a future date. The letter does not have an instruction clause. Demand letter should in paragraph convey express instruction and authority to act. The word promised by our client does not give authority, which have already captured Helen. The demand letter use threatening words and words that have been abusive, frivolous, vexatious, so which have Nicole have already captured. So each and every you have captured each, 2 points each, which were relevant. Yeah, so you can also be asked which is a key parts of a demand letter, which this are your question, which is in the year 2008 to 2019 Q&A. You can look at that, the answer there. So we go to the next question, which is 2. Assuming that your client Mujeuri Sana has actually been maintaining the minor, even though
Mwalimu, can I please interrupt you?
yes,
Are you projecting?
let me project. Can you see?
Yes.
So
Thank you.
assuming that your client Mujeuri Sana has actually been maintaining the minor, even though he's unsure if the minor is actually his biological son, draft an appropriate response to the letter. So 5 marks. So you don't draft a very big document. You consider the marks should be substantive. Letter should have all the components of the letter. So and I'm projecting Yeah. So, so telephone number. Oh, so today we are having internet issues. I don't know the problem, but we are going to continue. We are not going to cancel.
Okay.
So Nicole, I was saying,
Yeah.
so already the question have these facts. It's telling you you are going to act for, you are acting for Mujeuri. You are wakili shupavu. Can you see here at the end of the question? You are wakili shupavu, wakili mkubwa, and you work for mawakili hatari, and you work for Mujeuri. So on the address of the firm, you don't put KKLP Advocates because it's already provided in the question. Are we together to that point?
I think I read the wrong thing because I thought the advocates that drafted the letter were acting for the wife.
No. Yeah, assuming your account Mujeuri has actually been maintaining the minor. So you are doing the response to this demand letter.
Mm-hmm.
So that's why you must be very keen in looking at the question. So you answering this demand letter, which you have been written nyinyi. Mjeuri sana ameandikiwa. Unaona?
I'm lost because the letter is addressed to Mjeuri Sana and the firm of Mawakili Hatari are acting for the wife.
Let's see.
So I am basically supposed to come in as an advocate acting for the husband now and address the letter to Mawakili Hatari.
Assuming your client Mujeuri Sana actually been maintaining the minor, even though he's unsure minor actually biology, draft an appropriate response. So you are acting for who here?
I am acting from Mjeuri Sana, but the letter that has been drafted to Mjeuri Sana is from Mawakili Hatari Sana, who are acting for the wife. Utanijua vizu. I think, what's the name of the wife? The name of the wife should be
Utanijua vizuri.
Utanijua vizuri.
So the letter is
My
the letter continue.
sorry. My assumption was we already have a law firm for the wife, which is Mawakili Hatari Sana. And they drafted the letter directly to our client, who's basically this guy by the name Njeuri Sana, whom I'm supposed to represent, because they didn't know he has an advocate. So I want to assume he brings the letters to us, and then now we are acting for him. So I basically need to come up with the name of our law firm, which is basically going to act on his behalf and address the letter back to Mawakili Hatari Sana.
Now, you see, what the question is here is saying. Let's go sequentially. One of the firms, question one of the firms, and Njeuri Sana have been served with a demand letter below for a lawyer acting for his staggered wife. Yeah. I get your point. So here you are, so Mawakili Hatari Sana are acting for who?
They're acting for the wife, Utanijua.
Wakili Mkubwa is acting for this for Utanijua vizuri.
Yes.
So you are going to come up with a name of the firm, eh?
Yeah.
So then you are going to address to who? To Mawakili Hatari for Mawakili Hatari Sana. Mawakili Hatari Sana who are acting for
the wife now.
This working for the wife, eh?
Yeah.
So our reference, Mawakili Hatari Sana, River Road to us suit. I've gotten your point. Attention, Mawakili Sana, Wakili Mkubwa. Yeah, you are right. Dear Sas, alleged claim of child neglect by failing to provide maintenance for Master Mwerevu Sana. We make reference to a letter dated 27 Tesa and which Njeuri Sana, our clients, who has instructed to address you as follows. Yeah, our client acknowledges that sad a child by the name Mkubwa Sana with one Njeuri Vizuri. He, however, denies the allegation of pretending to be broke and refused to be provided for the child. Further, our client denies becoming your client at any point. We take note that our clients have been maintaining the minor from birth as a stranger to the allegation of being a dead father. Of concern, however, is that your client have frustrated all the attempts to have gain access to his child. For further, we know that your claim of Kenya shillings 2 million is unreasonable and passes off as money-making expedition by your client. Our client is determined on continuing to providing his child basic needs, but cannot pay the amount requested for by yours. Please provide us with a reasonable maintenance schedule. We are open to resolving these said issues amicably and out of court. We also request that you stay using vulgar language when addressing our client. We look forward to your prompt response. Yours faithfully, KK Pana, Kirau Mwara, acting from Njeuri Sana. Yeah, this is okay. Although the questions here, you could have put it, I've not seen it anywhere. The question talks about he has assured his minor actually his biological son. So you could have brought about something on biological son. So maybe they do DNA before starting paying.
I actually saw it. I saw that bit after I'd already concluded drafting, and now I was conflicted on whether to cancel out some bits and include it somewhere.
So every facts in an exams are very, very important. So to be safe in the future, underline, underline everything that you have been told, you think is it will help you answer. You'd underline,
Okay.
so that you don't forget. So that is you tried. I could have given you 4 marks. You have because of this. So Helen, answer. Yeah. So your reference. You have not mawakili hatari sana who are working. Mawakili hatari sana are, yeah, you do not start with the address of the person sending. Then you come to your reference. Wakili hatari Zidi House, that for that PO Box, Nairobi. Maintenance of Matasaravu. The matter refers. We like to respond to your demand letter dated 24th. Our client confirms that the child was born in course of this marriage to your client. You don't admit that because it's not sure. Maybe you ask for DNA. You have also confirmed that our client have been separated from your client. In respect to children in creche, Araka has requested for a paternity test to confirm the child is his, and no action has been taken in that regard. Our client is a responsible man and is willing to care for the child upon confirmation of the paternity. Our client has instructed us to therefore demand, which we hereby do, a paternity test for credible institution agreed by both parties. Any arrangement concerning the maintenance of the child shall be handed upon by confirming that the child and the cat are biologically related. So you ask faithfully that and that. So, yeah, response to a demand letter. You both tried, but then you did not do the address of the person sending the letter. Are we together?
Yes, yes.
So you can see the answer of the best performing student, Wakili Shupavu, Company Limited. This is the address of the person sent then the recipient to be delivered without prejudice. You see how he has a very good handwriting. In fact, he scored 20 out of 20 in this question. Response to your demand letter on maintenance of Samurevu Sana. We refer to your demand letter dated 24th and above. We act our client Jeurisana, which are instructed to you as follows. Our client has taken note of the contents to your letter, which are offensive. Our client avers that he has actually maintained the child utanijua vizuri as his own son, even though he's unsure of the paternity of children of the child. Our client denies any misconceived claim, not notion he was not maintaining the child. We have firm instruction to prevent any misadventure claim misadvised claim your client may have should your client continue to pursue and proceed with this suit, which may result into a liability as court of defending the suit. We hope this will not be necessary. Yours faithfully, and you copy. So the best performing student went the route of telling those people not to sue, and they are going to defend. Nicole has gone the route of telling them to propose the amount, reduce amount for maintenance, and you have Helen, you have gone the route of first of all claiming, asking them for a paternity test, which any that response is enough. All those responses are okay. Yeah, anyone any can work. Yeah, so we go to the next question because of time. Your people at the farm of Wakili Hatari draft a properly written letter to convey your client's grievances. Yeah. So this question is asking you now to draft this letter. The problem you have identified in one. You write a good letter. Let me see your answer, Nicole. Wakili Hatari, River Road, PO Box. Our reference dated Mjeuri Sana PO Box Nairobi Dear Sakrin for Metinda Mr. Mwerevu Sana. We act for Mtanijua Vizuri our client who has instructed us to address you as follows. You assigned a child by the name Mwelevu Sana, the minor, with your client. After his birth, you pretended to be broke and has not been provided for the minor. This is not legal language. Pretended to be broke. Are you together?
Yes.
Yeah, that is not legal language. So, yeah, and since I've been not provided for minor. Further, our client has made it known to us a continuous breakdown matter against her by us. We would therefore instruct you to desist from such failure, to which shall file a formal complaint. Our client has instructed us through this letter to request a total sum of 2 million being alimony towards the maintenance of the child basic needs. Despite the grievances between both parties, the interest of the child supersedes everything else. Yeah, so to save on time, you could have gone directly to requesting that you signed the child together and now you are asking for maintenance. Yeah, these other things were not very necessary. Make it formal. Take notice unless you comply within 30 days from there to 12, we shall commence proceedings. Yeah, we shall commence these proceedings or say we shall institute a suit against you without any reference to you, which are detriments are to the cost. Yours faithfully, Wakili Hatari Sana, and you copy to the client. So, yeah, I could have given you 4 marks because these things were not necessary. After birth, you pretended to be broke have since been provided for minor. Further, our client has made it known to continuous breakment against her yourself and therefore institute you to desist from such failure. Yeah. Helen, your answer? Yeah, our reference. So we have said you start with the address of what Nicole have done. You start with the address of the farm. So you're asking for Wakili Hatari Sana. So that is the address here. Are we together?
Yes, yes.
So this is a major thing, major weakness. I think it's because you do not attend the class we are doing demand letter in I think November 2021 or somewhere. So you start with the address of the person sending the letter. Then you come to our reference, your reference date, then the reference of the firm you are writing to. Yeah, you talk about it is you are writing to Mjeuri Sana, unaona? Because the question 1 was talking about you are looking at the this was drafted badly, question 1. So you are redoing question 1A. So you address your letter to Mjeuri Sana as Nicole has done. Yeah, Mjeuri Sana here. Maintenance of master who? It's called Master Sam Mwerevu Sana. That is your reference. You act from Tajijua Vizuri account where instruction we address you as follows. You are indebted to a client in sum of 2 million for maintenance of the child in born marriage in particular for which you are knowledge. Yeah. So it is not a debt. You are not indebted. You just you start by saying what Nicole has done. You start by doing an introduction. You said a child with our client Utanijua Vizuri Sana, which the child you have not maintained since birth. Even you can talk, give a date there. Then you go say, we are demanding to you, what? We are demanding to you alimony, 2,000 as alimony for maintenance of the child, 2 million. That is, of course, is backdated maintenance. Yeah. Despite numerous requests and demands hereby client for the settle for the said amount, you refuse or neglect to study or studying about to date. Good. In the circumstances or instruction are to demand, which we hereby do, we put here, which we hereby do, even in capital. Hereby do, yeah, hereby do, you do in capital, to immediate payment of the exercise sum of 2 million, which payment should be made within account with notification to us directly through us. Take notice that unless the said sum is paid within 3 months from date hereof, we have received the instruction to institute legal proceeding against you to recover the sums from you. We look forward from hearing from you. Yeah. So yours faithfully here should be your name, because the question is talking about your pupil. Yeah. So of course, active for Hatari Sana. So if you look at the question of the best performing student, of course, Wakili Hatari Sana, our reference Mujauri Sana, what I've said. Dear sir, defamatory maintenance of Master Seuri. We act for a client tunajijua vizuri have instructed us to write you and address you as follows. Our client avers that you are the father to utanijua vizuri. No, you are not. There was a mistake here. He was not the father. He's the father to Master Samuel Revu Sana. Our current father of us, since the birth of the child, you have not provided maintenance for the child. Yeah, you see, it's giving a background. Our current of us that you have instead asked her to maintenance and threatened to defame her on social media if he fails to comply. Our client of us that has asked you to take liability for maintenance of the child in good faith efforts we have frustrated. We hereby demand you to pay our client a sum of 2 million Kenya shilling towards the maintenance of the child. Take notice that failure to comply with the outside demand within 7 days of the receipt of the letter, we have instruction to instruct legal proceedings without further reference to you. We hope this will not be necessary. Yours faithfully, yours faithfully, Wakili Mkubwa for Wakili Hatari Sana. You sign. Yeah, so if you do those things I've told you, you are going to be good to go. So demand letter is not a very difficult question to do if it comes in an exam. Yeah, and it is tested in the past. All those areas had been tested in the past. And we don't need to dwell so much on question 1. We go to question B of 1B of Nini, which I'm going to read, is projecting on your screen. According to, let me see the time you took to do this question. Oh, we have not finished. Yeah, so let us finish. I see your time taken. B, according to the Reading Law School, the following passage offends the rules of plain English writing. Yeah. The case before us alleges that the plaintiff was taken to a hospital by paramedics where she underwent complicated surgery, and whether she claims she obtained the infection by means of negligence. The parties are in agreement by stipulation that only issues in the case are the surgeon's negligence and the staff negligence. The trial itself should be short as inter alia. The plaintiff recollection include only 2 witnesses. As of I mentioned, damages will only be discussed subsequent to the court's ruling on the issues. Assuming Aguedo, a verdict on the favor of the plaintiff is returned by the jury, the plaintiff will receive a substantial awards of damages. So 1, doing paragraphs in plain English sentences mistakes in paragraphs, sentences is a compulsory question. This is legal writing, drafting question compulsory. So you need to get this one. So Nicole, you answer. So what are the question asking you? Identify 3 words, clauses, phrases, or sentences that violate the rules of plain English. Yeah. Plain English, I introduce what is plain. We did like a class. So you are going to look at those past videos. I don't want to go back on plain English. What to look at the plain English notes before we started looking at this. Yeah, you look at those videos, I think in November 2021, like legalese and all those things. Yeah, so B1, use the word stipulation in the sentence and repetition of the words negligence. Yeah. So I said Nicole last time, when you say that you are removing this word and this, you must give the reason.
Yeah.
So yeah. So every time you have been told to remove, you must give the reason why you are removing. Yeah. So use the word stipulation in sentences and repetition of the word negligence. Yeah, why did you remove stipulation and negligence?
Okay, for stipulation is basically because it's it's making it sound like it's an assumption. They're not really confident on what is being communicated. And then for the word negligence, like they had a bit on surgeon's negligence and staff negligence, which could be reduced into one thing. Like
Yeah,
basically
that
maybe
is
staff negligence.
very good. That's what you ought to have said. That is answer is incomplete. Use of the other words like inter alia and as a formation. Why have you removing inter alia and as a formation?
Um, I'd want to go with they sound more of like legalese, and a layperson won't per se understand
Yeah,
when you
so that
tell
is
them a formation. Yeah.
so those are these are legalese. That's why you are removing them. You say that in exam. Use of the word aguedo, which is not aguedo, which is not plain English. Yeah, that one you said. Yeah, so yeah, so you could have gotten most accurate, like because I'm not explaining 2 points. Yeah, it's incomplete if you explain you remove words and you don't explain why. Only the third one you have a plain use of the word aguero, which is not plain English. Let me see your answer, Helen. Yeah, B1. Surgeon negligence and staff negligence. Assuming a verdict in staff negligence and surgeon's negligence and staff negligence. Why are you removing them?
I have summarized the surgeon's negligence and staff negligence to one statement because these are people that are acting in their professional capacity. So instead of repeating surgeons and staff who are working in the same professional environment, I put it as professional negligence instead of repeating surgeons negligence and staff negligence.
That was what you could have explained. Number 2, assuming a verdict in favor of the plaintiff is returned by the jury. So why are you removing this?
Because it is indirect speech. So I changed it from assuming a verdict in favor of the plaintiff. Assuming a verdict in favor of the plaintiff is returned by the jury, I changed it to assuming a jury decides in favor of the plaintiff. So there was indirect speech and also too many words.
Yeah. Oh, I've seen your answers here. So, you in an exam,
Yes.
in exam you don't put it down here. You see now, even I was not seeing your answer. You say why you are removing the words you are removing and why you are removing in the same line, in the
Okay.
same yeah. So the last one is aforementioned. Why are you removing of aforementioned?
I think it's legalese, so I just replaced it with as mentioned.
Yeah, as mentioned. Yeah. So you can see the how the best performing student have done this question. He got 20 out of 20 marks. So this is how we should do, and we talked about in the last paper when we are looking at this plain English. The words are in agreement by stipulation. So you put it in quotes. Then you say, why are you removing them? The phrase is verbose. The next is the surgeon's negligence and staff negligence. This is repetition and necessary use of the word negligence. Agredo, in quote. This is a foreign word whose meaning is not easily understood. Yeah. So she's giving the word and the reason, word and reason in one sentence. Are we together?
Yes.
Yes.
Yeah. So that's how you should do it in an exams. I wanted you to be excellent. So question number 2, the next question, and Helen, you tried, although you did not put together. Yeah, you put it together and you explain why you are replacing this and this. Yeah. So illustrate how each word's clauses, phrases, and sentence you identify in B above can be simplified to compare it with English writing. Yeah, in fact, this is your Helen answer now, number 2,
Yes.
Yes. So I was reading your answer number 2. So let me start with Nicole. Yeah, remove the word stipulation completed from the sentence and remove the word surgeon's negligence to remain with the standard term staff negligence. So stipulation you can be done away with, and surgeon's negligence to remain a standard term staff negligence.
I
Remove
think
the word
professional negligence would be.
sorry.
I think I'd go with what Helen said, professional negligence, not staff negligence.
Yes. Remove the word inter alia and you put in quotes. You
Yes.
can see here it will completely from the center replace the word information with mention. Yeah, so remove the word in me, I could have said remove the word inter alia completely, because if you read here, inter alia usually means is a legal term. Usually means what? It means Italia means among other things. That you can remove it here. The try itself should be short as the predictive recollection. So you have said this one can be done. As mentioned, damages. So even as aforementioned, also you can remove it. You just start with damages. So that's what I could have said. It does not serve any purposes. Use the word Aguero was unnecessary. It could well be removed. Good. The sentence will be then read, assuming a verdict in favor of the plaintiff is returned by the jury. It is likely the plaintiff will receive a substantial award. Yeah, this one you tried. So Aguero can be removed completely. So yeah. So you used 1 hour to do this question. You tried. You only need to reduce with like 10 minutes. Because you need I told you 15 minutes. The first 15 minutes is to read the questions. The last 15 minutes is to proofread and to add after Nini. Then the last 1.5 hours is to do the 5 questions, 50 minutes, the first compulsory, and the other you use 25 minutes. So this one you reduce, to be on the safe side, you reduce 10 minutes.
Okay.
Yeah, so yeah, we have already talked about the Nini. Let's see the answer of the best performing student. So use the word agree to reduce words from 5 words to 1 word. The word agree is base verb and should be preferred. The other words by stipulation is unnecessary verbose and should be omitted. Use the word staff negligent to shorten the sentence and reduce words from 7 words to 3 words. The phrase staff includes both surgeons and staff is therefore more appropriate generalization. Omit the word aguero. It is foreign word which should be easily comprehended. It also serves no major purpose in the sentence. So that's how you do the plain English. You identify the word and you say why you are removing it. If it is replacing it, you talk about it. And we are going to do more exercises on this area for you to perfect, because it's a compulsory area, it's a compulsory question. Are we together?
Yes.
Yeah, so we go to the next question. Helen, we are together?
Yes, yes.
Yeah, so I want you to perfect on this area because it's a compulsory area. So yeah, question 2 now. I've not looked at the time you have taken. You 9:13 to 9:31. This is like 7 9. Yeah.
For the
You
first
give it.
question,
Eh,
it took 1 hour 20 minutes.
yeah, you need to reduce on time, because you see, you can be perfect in drafting the documents, but you are using a lot of time. So that's what that does that mean? You do 4 questions or 3. You do 4. So you will not do the last question because the other 4 have taken the time for the other 1 questions. And that means you are not safe. You are not safe. It will make you fail. So drafting, you must use the time taken, correct time, and also you know how to draft. So perfect on timing,
Okay.
Yeah, so we go to the next question, which I'm going to read. Tom Yunis is an advocate of High Court of Gura, recently admitted to the bar. He soon get an associate position in Sina and Haraka and Pore LLP. His boss, Eva Haraka, immediately gave him first brief to handle on his own. His first client is Mwepesi. On the 24th June 2022, the case came up for mention to confirm whether the parties are complied with Order 11 of Civil Procedure Rules. However, it failed to proceed since the court was not sitting. Both parties were in court. It was then fixed for further mention on that January 2023 by the court clerk. On the same date, Eunice failed to attend court, having been unable to secure a means of transportation back to the city. The case was subsequently fixed for hearing on 18 January 2023. The opposing counsel was instructed to serve the hearing dates upon Eunice. So if you are looking professional ethics, you could be underlying ethical issues. But now this is legal writing. So when you are doing legal writing and drafting, you know how which question it must you must focus on the possible legal writing and drafting question. The opposing counsel was instructed to serve the hearing date upon Eunice. This did not happen, and the case proceeded expected without the opposing counsel producing before court an affidavit of service confirming that Eunice had been served with hearing date of 18th January 2023. Eunice still reading from December holiday hangover was an air of hearing date and having forgotten that the case even exists. On 14th February, Eunice is shocked when he served with a notice of entry of judgment by law firm of Utalali Sise Capital Advocates, indicating that judgment was delivered on 30th February 2023 and the client being found liable to pay 5 million to the other party. He immediately goes into panic, but even before the shock dissipates, he gets a call from none other than Mwepesi, of course, his client. Eunice, an introvert suffering from lethargical-induced phone anxiety, does not want to confront Mwepesi over the phone. He decides the best way to deal with the uncomfortable situation is to write to his client, informing of what happened, what had transpired. With foregoing in mind, identify the legal instrument Eunice would use to communicate to Mwepesi. In this situation, Eunice would draft a client brief. What is a client brief, Nicole?
I couldn't get an exact name for it. And I didn't want to say a case brief because a case brief is completely different from what she needed to draft. And I couldn't also say a client care because client care is completely different. I didn't have the exact word.
Okay. So, Helen, you answer. Client update letter. Yeah. So, that is the answer. Client brief. You know, you must defend your answer. And in an exam, you must state what is. If it is a client brief, you must say what a client brief is. Client care update letter. What is a client update letter, Helen?
A client update letter, from my experience, is a letter that is written by an advocate to a client to inform him or her whenever there is a what? But to basically inform the client of any developments concerning the case. If you have filed something, you can tell them you filed something. If a judgment has been issued, tell them a judgment has been issued. If, for example, if it was a transaction where documents need to be filed or need to be paid for, you tell them.
Yeah. So that is the answer. So you need just not you need to have explained. Just saying client update letter is not enough. You explain what it is,
Yes.
Yeah. So I'm reading online here. A client update letter. In brief, is a message, a letter to client which provides, for our purposes, information to client on the status of a case. Status of a case. That is enough. Unaona?
Yes.
Yeah, are we together, Nicole?
Yes, we are. So I should have gone with client update letter.
Yeah. So the best performing student which I'm projecting, he put it to letter to client. But he did not explain. You need to explain. This is not safe,
Yes.
Yeah, letter to client or client update letter. And you say what Helena said. It's just an update. Is a letter to client updating him or her or about the status of the case. So now we go to the second part of the question. Of course, draft the document and identify in A above. So 9 marks. So this letter should be as substantive as possible. for you to get 9 marks. So you know how to write, to draft letters. It's not difficult. Yeah. So yeah. So the question here, sina haraka wapole, the Oval Office, our reference, wepesi mno, so that, yeah, this is okay. Reference and dear sir, update on your case. So, cut on your case. So you give as many details as possible, which have already been given in the exam paper. You give the history and how you are going to salvage the situation. So the letter serves to update you in the status of your case. You have not been, the question has not given us the case number. Yeah, the letter serves to update you on the status of your case was scheduled mentioned on 24th December 2020 and the hearing on 18th January. The case was just set to formation on 24th December to confirm compliance with Order 11 civil procedure. However, the court did not sit that day and the letter was scheduled for mention on January 3, 2020, which an advocate from the firm attended. The case was fixed for hearing on January 18, 2020. Unfortunately, I was unable to attend due to transportation challenges. The opposing counsel proceeded with the hearing expected without serving an affidavit of service to confirm that I have been not been notified of hearing date. This is a procedural irregularity as a proper service is required to ensure all parties are aware of the court dates. On February 14, I received a notification of entry of judgment indicating the court had delivered judgment on February 13, 2020, finding you liable to pay 5 million to the other party. I understand that this news is distressing and I sincerely apologize for any conveniences caused by my absence to hearing. I'm currently exploring all available legal options to address the situation, including the possibility of appealing the judgment or seeking a review of the proceedings. I propose we meet you at earliest convenience time to discuss this matter further and determine the best course of action. In the meantime, please do not hesitate to contact me if you have any questions or concern. Yeah. So this is, you did well. Yeah. So it is the history, then you give what you are supposed to do, and the time is okay. 20 minutes, the maximum is 25 minutes. Yeah. So here you could have gotten maximum marks, 9 out of 10. So the only question you could have not gotten is the first bit. It's not called a brief. It's called a client update letter or letter to client. So yeah, now I'm looking at the Helen answer. You have not put the address of the, this is a weakness. You have not put the address of the law firm. Have you noted this weakness, Helen?
Yes, I have.
So in future, you must put the address, reference your, yeah, client mwepesi, telephone, email, DS update on your civil case. So you give the health title. You can give the civil number. That's okay. Yeah, you can, if it is not given in the exams, you can get your civil number, case number. Even the parties, you can put the parties. You have given us instruction to act on your behalf in civil case. The matter is recent motion on 27 December, but did not take place as the court was not sitting. The matter was later set for further mention on that February 22. The unfortunate did not attend mention due to transportation hiccups caused by the post-holiday rush. The matter proceeded for hearing on 18th January without my notice. I received a notice of entry judgment on February 23, being a confirmation that the judgment had been delivered against you and the sum of 5,000. First of all, I apologize for any inconvenience caused on my part. Further, I intend to make an application to set aside the judgment as legal procedure was not followed. So you have not talked about the affidavit. Remember, the question is saying that did not case expert without opposing counsel producing before the affidavit. So that is a very crucial fact.
Okay.
Yeah, affidavit. He was not served. The affidavit was not produced in the case that he was served properly. What Nicole have said. And the address, you do not put the address. That is two weaknesses. Yeah.
Yes.
So you could have gotten maybe 7 out of 9. Yeah.
Mwalimu,
Yes.
question kindly.
Yes.
In an exam setup, like let's say now in this question that we're dealing with right now, if I'm told to like maybe write the document that I'm supposed to draft and I get the document wrong, does it mean the marking stops from, like maybe if I was supposed to draft a legal opinion and then I indicate it's a case brief, but I draft a legal opinion, will
It's
they
0.
penalize me for that? Like will they? So now in this case, if I got now, because I wrote a client brief, then it means even if no matter how good my letter is, it will still
No,
be
no,
a
no, no.
0.
No. I'm saying, you see, question 1 is independent of question 2, So
Okay.
question 1, you said it is a brief. It is a, you have said it's what?
I wrote it as a client brief.
So it's a client brief. So that one you could have failed, because it's a letter. But the letter, you have done the letter well. Unaona?
Yeah.
So you could have passed. What I'm saying, what I'm saying, you get a 0, Is whereby, for example, they wanted you to draft your client care letter, you do a legal opinion,
Oh yes.
Yeah, if it is you don't know the document, which is what it is, you get a 0. After even if you have drafted very well, unaona. So for example, this question 2 is a client care letter, is a letter to client. Yeah, what you have said, a letter to client, or client update. Tuseme ulikuwa umefanya legal opinion, even if you have done it very well, you get a 0, because you must identify the document, because you are doing a that's why these are professional exams. It's marked very harshly, because you are being trained to become a professional. If a client instruct you, you go and file pleading in a different court from this. You are going, those pleadings are going to be struck out, and it's going to be the allows to the client. So that's why it is marked very strictly. Yeah, you must know what your document you are drafting, and you draft well. You look at the context. You must capture the content that there in the question. Yeah, because of course not all the facts are relevant, but context which are relevant to that question. That is what they usually look. And yeah, so yeah, so your time here, Helen, you said you have taken you took how many minutes to do the question?
18.
18 was okay. That is within time. Yeah. So now we go to the last question of the day. Yeah, which I now am going to read. We still have time, more than half an hour, so we can look at it. So question 3, the Republic of Itikadi has, through its legislative arm, the Assembly, introduced a new licensing plan to make sure that all persons who want to act as Garis Masoda license. On 6 January 2023, the Assembly passed the Licensing Act Act number 4 of 2023. The Act at Section 5 creates a licensing board which is mandated to oversee the administration and implementation of the plan. Meanwhile, Section 3 of the Act provides as follows. The licensing board may issue a license to individual to act as a guarist. The individual has not been convicted of a serious criminal offense. If the individual has recognized qualification in act related subject for a recognized university in Itikadi. Guarist holding licenses before the commencement of the act must apply for a license within 3 months of the entry into force of the act. Mwanasana works a Garis in Itikadi. She is not sure whether she needs a license. At present, she does not sell art but only values it. She has no criminal convictions and has a bachelor degree in art history from Huru University, which state of Itikadi. She applies to the board for a license just in case she needs to have one. Her application is refused. The board informs her she must stop her work immediately. So if you are looking at civil litigation, you could have looking at possible legal causes here. If this was a civil litigation question, but we have not seen any legal writing matter. So when you are reading a question, you must think, what is the legal writing question that is reading me to? The board informs her that she must stop her work immediately, as it does not have the required qualification that is therefore not fit on proper purpose to be a Garis. In a letter, the board informs her the decision is final and cannot be challenged in any court of law whatsoever. Mwanawasa makes a call to the board to see whether she really needs allowance and speaks to the decision maker, one Valenjo. Valenjo informs her that he considers that women neither make good carrots nor valuers. Mwanasasa becomes an administrator and calls the local newspaper who ran an article in their daily publication, Art is Life, about Mwanasasa's situation. An avid reader of the publication, Bear Hatari, hears of the problem and approaches Mwanasasa to let her know that he will be willing to challenge the decision on behalf of Mwanasasa, to charge her on her behalf. Mwanasasa is confused and distracted and comes to you for legal advice. So, draft the necessary legal instrument advising Mwanasasa about her case and bear Harry's suggestion to her about his role, bringing action on her behalf. So, the question is 10 marks. So, the drafting must be very substantive. So, legal opinion. That is correct, legal opinion. So, yeah, this is a legal opinion. When you are told to advise your client on a legal matter, when your client asks you to advise you on a legal matter, you draft a legal opinion. And a legal opinion is done just like a letter. It has 3 parts. It has I can even before. Yeah, let me see if I have a legal opinion. I can share in screen like this one. Or let me share. That one is complicated. Let me share Kingmaker's document. Before even we look at your legal opinion. Yeah. So let me pause. So on your screen is a legal opinion, courtesy of Kingmaker. If you are told to write a legal opinion, this is, of course, is done as a letter. Yeah. So you must have the address of the facts. What are the facts? These are the facts you're going to pick from the question. You identify the issues, and the issues, these are legal issues. Then this is where the most, this is where the problem usually gives student problems. Of course, the rule of law, you must know it, and application of facts to the law. This is where the problem usually is. Rule of law and application of facts to the rule of law. Because you must know the rule of law and then apply to the facts of the case. This is why it gives you the problem. If you are given to do a legal opinion and you don't know the rule of law concerning that legal opinion, and application of facts to the law, of course, don't try to do. Yeah. So you start is the letter Pole Samu, then our reference, your reference, like what we are doing in demand letter. Yeah, legal opinion on. So you must state on what is you are talking about. It must be a legal issue. Legal opinion on instituting an appeal against Mathare Rana. Introduction. Yeah. So you give the facts, which is according to the question. Which are the issues? It must be legal issues. Whether it was lawful to grant summary judgment to the company, that is a legal issue. Whether the company is liable under theory of vicarious liability. So summary judgment is rules is usually defined. Is usually governed by from your civil procedure rule class is order 36 rule 1. And vicarious liability, you know the elements of vicarious liability. You can put precedents. These are not relevant in the exam scenario. I will discourage you to put case laws. You will not get case laws and you take a lot of time. Then application of the rule on the facts. You must apply well and then give the conclusion. What is the conclusion? It was considered opinion that the lower court erred in granting summary judgment to the company. The company should therefore be liable in the area of vicarious liability. This is because Mr. Kasuku was neglected and cut the scope of this comment. Conclusion. Then what is the recommendation? The appeal. You recommend that you proceed to institute the appeal against the decision. Yeah. And yours faithfully. Opinion. Nicole.
Yes.
You have heard what I've said about doing a legal opinion, eh?
Yes, I have.
Yeah, Helen.
I have.
So that is very, very important. Legal opinion is a very this is legal drafting is a question that is tested a lot, but the problem usually comes from rule of law and applying facts to applying the facts given in the question to the rule of law. And that's why I usually tell you don't look when you're doing this thing. In an exam scenario, if you're given some facts that you don't know the rule of law, yeah, don't try that question. Because even if you don't know the rule of law, you cannot apply the rule of law to the facts. Yeah, so now I'm looking at the Nicole answer. So yeah. So KKLLP first floor suite 4 a reference Mwanasasa Mzuri PO Box, dear madam. That will earn some few marks. Legal opinion regarding licensing requirements of grass in Itihadi. Yeah, that is a legal issue. Good. You refer to the above matter. Be careful review the details of your case and accounts surrounding your denial of license to operate at Garis Value Based on our analysis, we provide you with the following legal opinion regarding your position and available options. You work as a garrison in there, but currently value no sell, no criminal conviction, hold a bachelor in art history. In exam scenario, I'm advising you, don't, because the examiner will not look at the facts very much. So you try to summarize the facts from they can give you a very long story. So they will not mark you on facts. They will mark you on, of course, the address of the person doing the opinion, your reference, the reference of person you are doing, dear madam, reference, your opinion. On facts, try to summarize them. It may take a lot of your time. So that is not a very relevant place they usually mark, because the facts you are going to pick them together. So you recently applied for girls races as a precaution, but the board rejected your application, stated you lack the required qualification and must cease work immediately. The board assented its decision as final and not subject to issue. So now this is where the rubber meets the road. What are the issues? Whether you are working as a garage who values but not sell requires a license. That's a legal issue. Whether your activities follow and acting as a garage as defined by the Act is also a legal issue. So you are going to the rule of law is going to be based on the issues, even your analysis. So the question also brought another issue which you have not talked about. Suggestion about his role of bringing an action on behalf. So the other issue was whether Bear Hatari can bring a case on his behalf. Are we together? Nicole?
Yes, we are.
Yeah, so that one you did not bring, eh?
Yeah.
Another issue is whether he can appeal, whether the decision by the board is final. That's another legal issue. So you go now to the rule of law, even before you come to the analysis. What is the rule of law you are going to nini? To do your analysis? You can talk about Constitution of Kenya. Article 47. You can talk about this act that is given here. Yes, this is Act, Licensing Act of 2023. Article 47 of the Constitution of Kenya. You can talk about Mutunga rules. You cannot talk about Fair Administration Action Act. You can talk about Fair Administration rules of 2024, because these are constitutional issues. Yeah. You can talk about Article 2022, whereby a person can bring an infringement of a constitutional rights on behalf of another person. Yeah, enforcement of Bill of Rights. So rule of law is next. Then we see your analysis. Based on the information provided, it's likely that you don't require a license to operate as a guide, even if you are not currently selling and art. The board refusal of the application and board's refusal of application and this work may be legally questionable, depending on specific provision of the act and the reasons of the refusal. Further, clarification needed regarding the board's interpretation acting as a guide and required qualification. Further, Act Dealers of 2020 mandates that individual acting as guides must hold a license. Section D outlines the license provider stating that the licensing board may issue a license unless the individual have criminal record. Acts recognize qualification in acts. It also requires existing galleries to apply you for license within 3 months of the act's commencement. If acting as a gallery encompassing varying it even without selling, then you are likely require a license. The board's decision suggests that they interpret act this way. However, the decision may be fraud. Mhm. The act does not define acting as a grace to include valuing without selling. You may not need a license unless you engage in sales. Your art history degree qualifies as recognized qualification in art-related subjects. The board rejection implies they do not consider your degree sufficient, but this interpretation may be too narrow. The board did not provide specific reason for rejection. Procedural fairness declares that boards should provide clear reason for refusing your application and you to address any deficiencies. The board's assertion that the decision is final and charitable is likely correct. General administration decision are subject to judicial review. So you can talk about even rule of law, you can talk about section 9 and 8 and 9 of Law Reform Act, especially if there are grounds to believe the decision was unreasonable, a procedural unfair, or based on incorrect interpretation of the law. For analysis, it's our opinion that you request for a formal written application from the board on considering appealing the decision. In conclusion, your situation requires further clarification and potential legal action. The legality of the board decision hinges on interpretation of the act leaders and specific the reasons for the rejection. You should take steps to obtain more information and protect your rights. Yeah, so you tried. Deficiency number one, I've pointed out you did not put the law here before you go to the analysis. Of course, issues you did not capture, especially this issue of Pear highly suggestion to her about his role on bringing an action. Then you did not talk about your conclusion is not very good because remember the board already have said that the decision is final. So you cannot tell her to go back to the board and seek more information. Is the decision is to sue. To seek redress in the High Court. Are you together?
Yes, we are.
Yeah, you asked for the KLLP. So because of those three deficiencies, that is maybe 6 out of 10. Time taken 35 minutes. Reduce time to 25 minutes only. So you in future when you doing legal opinion, summarize the facts.
Yes.
The time was, I know you took a lot of the facts. The facts summarize. Go to the issue in the facts. What are the factual issue? Yeah, go directly to that because already that one is provided in the paper. You may not be marked. What they usually look at when they are marking legal opinion is the reference of the NINI, the address, the references, the addressee, recipient address, dear mother, legal opinion, issues, what are the issues, what are the rule of law, your analysis, conclusion, and recommendation. Now I'm on your answer. Helen Omega Company Advocates ABC. Good. Reference, your reference. Date. Mwanasasa Binti, telephone. Legal opinion on the administrative decision of our Ata Decency Board. You did not put dear madam here. Dear madam before reference. You forgot, Dear madam before you start the reference,
Okay.
So the above matters refers. You made an application to the Art Dealers Licensing Board for a license that would permit you to do an art gallery. The application is initially rejected without reasons. You made a call to inform the application was rejected and the answer was unreasonable. Furthermore, the board informed you that their decision is irrevocable. You have also stated that the Behari wishes to institute a suit on your behalf. Good. This is a summary I'm talking to you, to the Nicole. This is a summary. Yeah, so this is a summary I was telling you. So Helen has summarized the facts very well. Yeah, so what are the issues? Whether the administrative action by the board was fair. So you put here by the board. Whether the administration action by the licensee board was fair, after you can put in question mark, whether the decision is irreversible, or say whether the decision by the licensee board is final, whether Hatari can institute a suit on your behalf. Yeah. So you have captured whether Mitsubishi can institute a suit on your behalf. On behalf of Mwanasana. Remember, you are writing to Mwanasana. So you don't talk about Mwanasana. So whether Hatari can institute a suit on your behalf. Are you getting?
Yes, yes.
That is the language. So analysis, you take each and every rule of law. I've already talked about rule of law. You put it here before you go to the analysis. You can talk about the Constitution of Kenya, Article 22 and 47 and 22. You can put here Section 8 and 9 of Law Reform Act, Fair Administration Action Act, Fair Administration Rules 2024. Yeah. Even if you don't know what this, you know the analysis, even if you don't know specific what they say. But of course, you know how the analysis you are going to do. So on analysis number, whether administrative action was fair. So whether the administrative action by the license board was fair. One, Mr. Vara confirmed via phone call that your application was rejected as does not believe that a woman can make good regardless of values. Article 27 of the Constitution protects all citizens against form of discrimination, and in this case, gender or gender. Consequently, the decision made despite undiscriminative and has unreasonable. Further, she once given audience, yet she's qualified. Yeah. So you have talked about Article 27 on administration, on discrimination. Then you can talk about Article 47 on Fair Administration Acts. Then whether the decision is reversible or whether the decision by the licensing board is final. The decision of the board can be opposed through an application for judicial review. This is in line with the Fair Administrative Action Act 2024. The board statement that the state nature of the decision is against the law. Yeah. Whether Mwebe Hatari can institute legal proceeding on your behalf. Good. So Article 22 of the Constitution of Kenya 2010 has provision on local standing. One must have a direct interest in the subject matter. If not, one decision is instituted on behalf of a minor, a person of sound mind, or with the matter of public interest. A suit can also be instituted on behalf of many plaintiffs or defendant by one of them, where there are many, and this can set to there. Behatari does not fall within the confines of what the state representation and texture litigation. Consequently, he cannot dispute the suit on your behalf. Is that the correct interpretation? Is correct analysis, Helen?
I with Mbehari, what is the name of the lady? Mwanasana is not a minor. She's not a person of unsound mind. The matter itself is not a matter of public interest. So what I was trying to say was that Mbehari or Mwanasana does not fall within any of these groups, or the matter that is in question does not fall within any of these groups.
So I want to read Article 2022 too. We interrogate.
Okay.
So a person acting on behalf of another person who cannot act in his own name. So it is out. A person acting as a member of or interest of groups or class of persons, that is out. A person acting in public interest. Or an association acting in interest of one or more of its members. So those are 4 things which does not fall on that. So you are right. Your analysis is correct. It does not fall under the 4 things I've read in Article 22.2. So you need to, that your analysis is correct. So conclusion, your administrative action was the administrative action by the board was unfair. You can make an application for judicial review. Bear is send cannot institute on your behalf. Yeah. Yeah. So yeah, conclusion and recommendation you can combine. You can even tell her, you can now give us instructions to file a judicial review application in the High Court to quash the decision of the licensing board. That's how you recommend. You must recommend now what he does to do. Unaona?
Okay. Okay.
Yeah, so you did better, Helen, than Nicole. Your analysis was very good, but both of you did not put the rule of law. So in the future, put rule of law. Yeah, put rule of law and the language which the language, draft the language which I've told you.
Yes.
Yes.
Yeah, so you could have gotten maybe 8 out of 10. Yeah. So legal opinion, remind me, we are going to do more in coming days. When we reach 2024 papers, we are going to do more legal writing and nini. Legal opinion, because it's a very common question. You perfect. So we have come to the end of this class. Kindly subscribe to the YouTube channel if the video is good. Next video is question 4, 5, and 6, March 2023. Yeah.